Welcome to Sure Short Questions with Narayan. In today's episode, we will discuss about comparative public law consisting of very short answer type questions, short answer type questions and long answer type questions, that is VSATQs, SATQs and LATQs. These are important for the law graduates, law postgraduates, UGC-NET law aspirants, UPSC, state PCS and other law related competitive exams. Let's start from question number 1. What do you mean by public law? Mind the keywords in the answers. The law that governs the relationship between individuals and the state, as well as the structure, functions and powers of government entities, is known as public law. It primarily deals with issues that affect society as a whole and ensures that government actions are conducted lawfully, maintaining accountability and protecting citizens' rights. What is the primary focus of public law? The primary focus of public law is to regulate the relationship between individuals and the state. It ensures the lawful functioning of government institutions. It regulates the relationship between individuals and the state. These are the keywords you must remember. What is the importance of public law? Public law is important for maintaining order, safeguarding individual rights, and ensuring the proper functioning of government institutions. It fixes accountability, protecting public welfare, and promoting justice in society. Who are the parties involved in public law cases? The parties are the state government, that means public authorities, government departments, or officials acting in their official capacity, individual or groups, the judiciary in adjudicating disputes, prosecutors or law enforcement in criminal cases, international parties. They are parties involved in public law cases. What, according to you, is comparative public law? Comparative public law is the study of the similarities and differences between the public law systems of different countries. It examines constitutional, administrative, and criminal laws across jurisdictions to gain a deeper understanding of how laws are structured, interpreted, and applied in various legal systems. Name the main branches of public law. They are constitutional law, administrative law, international law, and criminal law. What role does private law play? Private law regulates the relationship, rights and obligations between private individuals and entities. Here the concept of state or government is absent. It primarily focuses on resolving disputes and governing interactions in personal, commercial and property matters without involving the state as a direct party. State can be a direct party when the state acts in the capacity as a private party. State the difference between public law and private law. Public law governs the relationship between individuals and the state and the functioning of public institutions, whereas private law regulates relationships between private individuals or entities without state involvement. How does comparative public law differ from private law? Comparative public law involves the study and comparison of public law principles, systems and frameworks across different legal systems, whereas private law regulates relationships between private individuals or entities without state involvement. What is the main source of law in a civil law system? The main source of law in a civil law system is codified statutes and legislation. What is the role of president in common law and civil law system? In common law system, president plays a crucial role in developing law. Judicial decisions, particularly those made by higher courts, are binding on lower courts. This means that decisions made in previous cases are followed in future cases that present similar facts or legal questions. Whereas in civil law system, president does not have the same binding authority as it does in common law systems. Instead, codified statutes are the primary source of law and presidents primarily serve to interpret and apply those laws rather than create them. How do judges function in a common law system compared to a civil law system? In common law system, judges play an active role in shaping the law through their decisions as judicial rulings become binding precedents for future cases. Whereas in civil law system, judges have a more restricted role compared to their counterparts in common law system. Judicial decisions in civil law system do not create law, as codified statutes are the primary source of law. Judges focus on applying and interpreting these statutes rather than making new law. What is the nature of the Indian Constitution? Indian Constitution, it is federal in nature but unitary in spirit. Second is, it is rigid as well as flexible. It is flexible for an amendment that needs simple majority, but it is rigid when there is an amendment to the constitutional provisions. What is federalism? Federalism is a system of government in which power is divided between a central authority, that is the union, national or federal government, and constituted units like states in India and provinces or states in the US. Each unit has its own set of responsibilities and autonomy, which allows for local governance while maintaining unity at the national level. How do the UK, US and the Indian Constitution address fundamental rights? In the US, fundamental rights are protected by the Bill of Rights. That means the first 10 amendments after the enactment of the US Constitution, which includes freedoms such as speech, religion, and due process of law. In the United Kingdom, it does not have a single written constitution but protects fundamental rights through common law, statutes like the Human Rights Act of 1998 and EU law. EU law until Brexit. After Brexit, it is not existing. Indian Constitution. Fundamental rights are guaranteed in Part 3 of the Constitution, covering rights like equality, freedom of speech and protection from discrimination, which are enforceable by the judiciary. Which country first introduced the institution of ombudsman and when? The institution of the ombudsman was first introduced in Sweden in 1809. Sweden is the first country that established the institution of ombudsman, like Lokpal in India. What is the role of the ombudsman in Sweden? In Sweden, the ombudsman plays a crucial role in ensuring government accountability and protecting citizens' rights. It ensures that government authorities act in accordance with the law when dealing with citizens. What is the Lokpal in India? Lokpal is an anti-corruption body in India that investigates corruption cases against public officials, including the Prime Minister, Union Ministers, Members of Parliament and senior officers of Group A and B of the central government. What is the main function of the Lokpal? The main function of the Lokpal is to investigate allegations of corruption against public officials, including the Prime Minister, Union Ministers, Members of Parliament and senior government officers. It aims to ensure accountability and transparency in public administration by addressing complaints of corruption and recommending appropriate action or prosecution. What do you mean by plea bargaining? Plea bargaining is a legal process in which the defendant or the accused and the prosecution reach an agreement where the defendant or the accused agrees to plead guilty to a lesser charge or to receive a reduced sentence in exchange for certain concessions. This process helps expedite legal proceedings and reduces the need for lengthy trials. Plea bargaining, when was plea bargaining introduced in India? Here the question is missing. Let me write it. When was plea bargaining introduced in India? Please bear with me. It was missed by mistake. It is not such a good handwriting now. Please bear with me. The question is, when was the plea bargaining introduced in India? Plea bargaining was introduced in India through the Criminal Law Amendment Act of 2005 and came into force from January 11 of 2006, the very next year. Plea bargaining is allowed in cases involving non-serious offences, excluding serious crimes like murder, rape and corruption, to expedite legal proceedings and reduce the burden of courts. Is plea bargaining allowed in the US? Yes. Plea bargaining is allowed in the United States. It is a common practice in the criminal justice system where the defendant agrees to plead guilty to a lesser charge or to the original charge with a reduced sentence in exchange for a more lenient punishment. How is the UK Constitution different from the US and in India in terms of form? In the UK Constitution, it is unwritten, flexible, evolving through statutes and practices. US Constitution is written, codified and rigid with a complex amendment process. In India, we have a written constitution, codified, flexible with provisions for amendments but with some rigidity. Which type of system of governance is followed in the US, UK and India? In US, it is federal republic with a presidential system. In UK, it is a unitary parliamentary system with a constitutional monarchy. And in India, it is a federal parliamentary system with a constitutional republic. How does the Indian criminal justice system aim to protect rape survivors during trials? Through it, the criminal justice system aims to protect rape survivors during trials in the following way: by maintaining victims' privacy and confidentiality, that is anonymity and in-camera trials; support during the court proceedings, that is victim assistance and psychological support; specialized courts like fast track courts, sexual offense courts and POCSO courts; victim protection and safety, protection from the accused, non-confrontation with the accused; legal provisions for fair trial, no character assassination, and there is provisions for witness protection. What are the challenges in implementing rape laws in India? Challenges in implementing rape laws in India are inefficient law enforcement, delays in trials, lack of sensitivity, victim blaming and social stigma, underreporting of cases due to fear of societal backlash, complexity of legal procedures and inadequate training for police and judiciary personnel. These are the challenges in implementing rape laws in India. What was the significance of the Hussain Ara Khatun versus State of Bihar case? The Hussain Ara Khatun versus State of Bihar case of 1979 was significant because it highlighted the issue of undue delay in trials and the right to a speedy trial under Article 21 of the Constitution. The Supreme Court ruled that the right to a speedy trial is a fundamental right, emphasizing that prolonged detention without trial violates a person's rights to personal liberty and justice. Write a short note on public law. Public law is the branch of law that governs the relationship between individuals and the state, as well as the functioning of public authorities. It primarily focuses on ensuring that government actions are lawful, just, and in line with constitutional and statutory frameworks. The aim of public law: to maintain the balance between the power of the state and the right of individuals, ensuring accountability and transparency in government actions. Public law is concerned with the rights and duties of the state and its citizens, regulating the exercise of government powers and protecting individuals from potential abuses by the state. Areas of public law. Since we are writing a short note, these are the points need to be written. The areas of public law are constitutional law that governs the structure, powers and duties of the government and the rights of citizens. It deals with issues such as the separation of powers, federalism and fundamental rights. Administrative law. It deals with the regulation of government agencies, the powers of public authorities and the procedures by which public bodies make decisions. It ensures that public administration follows legal principles. Third is criminal law. It is concerned with the actions that are offences against the state, including crimes and punishments. It ensures that justice is served for acts that harm society as a whole. Tax law. It regulates the taxation system, the collection of taxes, and the rights of the state in imposing taxes on individuals and entities. Write a short note on the Jan Lokpal Bill. The Jan Lokpal Bill is a proposed anti-corruption legislation in India aimed at creating an independent and powerful institution called the Jan Lokpal, that is People's Ombudsman, to investigate corruption cases involving public officials. The bill was first introduced in 2011 as a part of the anti-corruption movement led by social activist Anna Hazare. The Jan Lokpal would be empowered to investigate and prosecute corruption cases involving ministers, lawmakers and bureaucrats without the interference of the government. The key features of the Jan Lokpal Bill are: independent body. The Jan Lokpal would be independent from government control with members appointed through a transparent and participatory process. Powers to investigate and prosecute. The Jan Lokpal would have the authority to investigate corruption cases and recommend prosecution without political influence. Third, protection of whistleblowers. It would provide protection to whistleblowers to encourage reporting of corruption. Fast track courts. Cases investigated by the Jan Lokpal would be fast tracked in courts to ensure swift justice. While the bill received widespread public support, it faced resistance from the government, particularly regarding the independence and scope of the proposed institution. Though it was not passed in its original form, the movement raised public awareness about corruption, and this led to the enactment of the Lokpal and Lokayuktas Act of 2013. That means that the Jan Lokpal Abhiyan, that movement laid the foundation stone for the enactment of Lokpal and Lokayuktas Act of 2013. Differentiate between private law and public law. Let's discuss on 7 headings, that is basis of comparison. Private law, what does it do? It governs the legal relationship between private individuals or entities, whereas public law governs the relationship between individuals and the state or public authorities. The examples of private law: contract law, tort law, family law, property law. Public law examples are constitutional law, administrative law, criminal law, tax law. Purpose. The purpose of private law is it protects individual rights and resolves disputes between the private parties. The public law ensures public order, regulates government actions, and protects societal interest. The parties involved in private law are individuals, private individuals, organizations, or entities. In the case of public law, it is the government and the individuals. Jurisdiction. In the case of private law, cases are usually resolved in civil courts. In public law, the cases are typically resolved in public courts such as criminal court, administrative tribunals, etc. Nature of violation. Violation of individuals' rights or interest in the case of private law. Violation of laws that affect society or state functioning in the case of public law. The outcome in private law is compensation or specific performance. In the case of public law, it is punishment that includes imprisonment or state action to enforce laws. Write a short note on separation of power in India. Separation of power in India, it is the distribution of government powers and responsibilities among 3 distinct branches. These are the legislature, the executive, and the judiciary. The principle is enshrined in the Indian Constitution to ensure a system of checks and balances, preventing any one branch from gaining excessive power and safeguarding the democratic structure of the government. The legislature, the Parliament of India, comprising the Lok Sabha, the House of People, and the Rajya Sabha, the Council of States, is responsible for making laws, controlling public funds, and overseeing the functioning of the executive. The legislature ensures that the government remains accountable to the people. Here, this is the photograph, the image of Indian Parliament. It is one of the 3 organs. Second is executive. The executive headed by the President of India includes the Prime Minister and the Council of Ministers. It is responsible for the implementation of laws and policies, conducting foreign affairs, and managing day-to-day governance. The executive acts as the administrative body of the government. Here it is an image of the current Prime Minister and some of his few former colleagues and current colleagues. Judiciary. The judiciary, led by the Supreme Court of India, interprets the laws and ensures their proper application. It has the power to review the constitutionality of laws passed by the legislature and actions taken by the executive, ensuring that the government operates within the framework of the Constitution. This is the apex court of India, that is the Honorable Supreme Court. Separation of power keeps checks and balances, prevents abuse of power, and ensures judiciary independence and protects citizens' fundamental rights. Discuss the separation of power in United Kingdom. The concept of separation of power in the UK is division of government functions among 3 branches, the same as in India: the legislature, the executive, and the judiciary. UK does not have a strict separation of power as in the US. In its systems follows a blended approach to ensure checks and balances. The legislator, Parliament comprising the House of Commons and the House of Lords, is responsible for making laws. Executive, the Prime Minister and the Cabinet execute laws and manage the administration. Judiciary, independent courts interpret and apply the law. Features. Fusion of power. The Prime Minister and Cabinet are drawn from Parliament. It shows a fusion of powers. Judiciary independence. Judicial independence is upheld particularly after the Constitutional Reform Act of 2005, which established the Supreme Court and separated the judicial role from the House of Lords. This approach ensures mutual cooperation while maintaining accountability and preventing the concentration of power. Write a short note on Lokayukta. Lokayukta is an institution in India established to investigate complaints of corruption and maladministration against the public officials, including government employees, ministers, and even the Chief Minister. Lokayukta is a state-level agency. The Lokayukta is aimed at ensuring accountability and transparency in public office and protecting citizens from corrupt practices. The features. Establishment. Lokayukta is typically established by state governments under the Lokayukta Act of 2013. The institution may also be present at the national level, though some states have adopted their own Lokayukta legislation. Functions. The Lokayukta investigates complaints against the public servants for corruption, bribery, misappropriation of public funds, and other unethical practices. It has the power to recommend disciplinary actions, including dismissal from service. Powers. The Lokayukta can conduct inquiries into complaints and can refer cases to the courts or other authorities for action. While it does not have judicial powers to directly punish offenders, its recommendations carry significant weight. Independence. The Lokayukta operates independently of the government, ensuring impartial investigations. It is typically headed by a retired judge or an eminent person of high integrity. Importance. Lokayukta plays a crucial role in the fight against corruption by offering a legal avenue for citizens to challenge government malpractices. It serves as a watchdog to promote transparency and accountability in governance. Discuss judicial activism in India. Judicial activism in India refers to the proactive role played by the judiciary in upholding constitutional values and protecting the rights of citizens, often stepping beyond its traditional role of interpreting laws. It emerges as a response to the legislative and executive inaction or failure. The features. Public interest litigation, a significant tool of judicial activism. PIL allows courts to address matters of public interest even if filed by individuals or not directly affected. Expansion of fundamental right. The judiciary has broadened the scope of the rights under Article 14, 19 and 21, interpreting them to include environmental rights, the right to privacy and the right to live with dignity. Checks on government. Judicial activism ensures accountability of the legislature and executive by striking down unconstitutional laws and actions. Let's discuss few case laws. Keswanand Bharti versus State of Kerala. It introduced the doctrine of the basic structure of the Constitution. In Maneka Gandhi versus Union of India, it expanded the scope of Article 21. Vishaka versus State of Rajasthan laid down guidelines to address sexual harassment at the workplace. Judicial activism has strengthened democracy in India, but has also faced criticism for encroaching on the domain of other branches of government. Discuss judicial accountability. Judicial accountability is the responsibility of the judges to act in accordance with the principles of fairness, impartiality and integrity while upholding the law and the Constitution. It ensures that the judiciary remains transparent, ethical and answerable to the public. Its features: independence and accountability. While judicial independence is crucial, accountability ensures that this independence is not misused. Mechanism for accountability. Judicial Standards and Accountability Bill, it is proposed, not yet passed. It aims to establish standards of judicial conduct and create mechanisms to handle complaints against judges. Impeachment process. Judges of the Supreme Court and High Courts can be removed only through impeachment, ensuring a high threshold for accountability. Judicial review. Courts ensure adherence to the Constitution while being subject to the Constitution themselves. Ethical conduct. Judges are expected to follow a code of conduct to maintain public trust in the judiciary. Challenges: lack of transparency in judicial appointments and proceedings, limited mechanisms for addressing misconduct by judges. It is important because judicial accountability is essential for upholding the rule of law, safeguarding democracy, and maintaining public confidence in the judiciary while balancing its independence. What is PIL? PIL stands for Public Interest Litigation. It is a legal mechanism that allows individuals or organizations to file cases in courts on behalf of the public, particularly for the protection of fundamental rights and addressing issues affecting disadvantaged sections of society. It is a tool to ensure justice and accountability even for those unable to approach the courts themselves. Features: access to justice. Any public-spirited individual or group can file a PIL even if they are not directly affected by the issue. Relaxed procedure. The courts have simplified procedural rules for PILs to encourage access to justice. Wider scope. PILs can address issues like environmental protection, human rights, corruption, and governance. The landmark cases are Hossain Khatun versus State of Bihar. It highlighted the plight of under trial prisoners. MC Mehta versus Union of India focus on environmental protection and establish the concept of sustainable development. Visakha versus State of Rajasthan addressed workplace harassment and formulated guidelines. What are the executive actions discussed? Executive actions are the decisions, policies, and measures taken by the executive branch of the government to implement laws, administer public policies, and manage the affairs of the state. In India, the executive comprises the President, Prime Minister, Council of Ministers, and government officials at various levels in the Union. In the state level, it is the Governor, the Chief Minister, and the Council of Ministers and the officials. Features: the nature of executive action are administrative in nature and ensure the enforcement of laws passed by the legislator. They can be classified as legislative actions, issuing ordinances or rules under delegated legislation; judicial actions, quasi-judicial decisions such as resolving disputes in administrative matters; administrative in actions, day-to-day governance, implementation of policies, and management of public services. The scope: executive actions cover a wide range of functions, including maintaining law and order, foreign relations, and managing public welfare programs. Examples: issuing guidelines for implementing welfare schemes, declaring a national emergency under Article 352 or financial emergency Article 360, signing international treaties or agreements. While executive actions are essential for governance, they are subject to judicial review to ensure they do not violate constitutional provisions or fundamental rights. Compare the ombudsman system in India and UK. In India, Lokpal 2013 and Lokayuktas at the state level, this is the establishment. In UK, the Parliamentary Commissioner for Administration Act 1967. The scope of the jurisdiction: in India, it covers public servants, MPs, Prime Minister, ministers, and Class A and B gazetted officers of the central government. In UK, it covers central government departments, local authorities, and NHS, that is National Health Scheme. Appointment: the Lokpal is appointed in India by a committee including Prime Minister, Speaker, and Chief Justice. In UK, it is the Ombudsman. They are appointed by the Crown on the recommendation of Parliament. The authority: in India, Lokpal has investigative and recommendatory powers. In UK, Ombudsman provides recommendations which are usually followed but not legally binding. Focus: the primary focus of Lokpal in India is corruption and maladministration. In the UK, it is maladministration and improper conduct in public services. How did Marbury versus Madison influence the development of American constitutional law? The landmark case of Marbury versus Madison of 1803 is a cornerstone in American constitutional law, as it established the principle of judicial review, empowering the judiciary to review the constitutionality of laws and executive actions. Contributions: establishment of judicial review. Chief Justice John Marshall ruled that it is the duty of the judiciary to determine whether laws passed by the Congress are consistent with the Constitution. This gave courts the authority to invalidate unconstitutional laws. strengthened the constitution. By declaring the constitution as the supreme law of the land, the decision ensured that no legislative or executive action could override it. Balance of power. Marbury versus Madison defined the judiciary as an independent and co-equal branch of government, establishing checks and balances among the three branches. Landmark precedent. The case has been cited in numerous subsequent rulings and remains the foundation for judicial interpretation of constitutional issues. What was the impact of Marbury versus Madison? The decision fundamentally shaped the American legal system, ensuring the protection of constitutional principles and individual rights by providing the judiciary with a mechanism to oversee the actions of other branches of government. What are the white-collar crimes? White-collar crimes are non-violent, financially motivated offences committed by individuals, typically in professional or business settings, to gain personal or organizational advantage. The term was introduced by sociologist Edwin Sutherland in 1939. Features. Nature of crime. These crimes involve deceit, manipulation, or breach of trust rather than physical force or violence. Offenders. Generally committed by individuals in high status positions such as corporate executives, public officials, or professionals like doctors and lawyers. Examples: fraud, bank fraud, insurance fraud. Embezzlement, that is insider trading. Embezzlement means misappropriation of money. Insider trading, money laundering, tax evasion, etc. Effects. White collar crimes cause significant financial losses, harm investor trust, and undermine economic stability. The legislation in India to deal with white collar crimes are: Indian Penal Code covers offences like forgery and criminal breach of trust. Special acts are Prevention of Corruption Act of 1988, Companies Act of 2013, SEBI Act of 1992 that deals with insider trading. Discuss the juvenile justice system in India. The administration of juvenile justice in India is governed by the Juvenile Justice Care and Protection Act of 2015, which ensures the care, protection and rehabilitation of children in conflict with law and children in need of care and protection. Special provision for juveniles. Children below 18 years of age are considered juveniles. Juvenile offenders are not treated as adult criminals but are provided with opportunities for reformation. Juvenile Justice Board (JJB). Cases involving juveniles in conflict with law are handled by the JJB, consisting of a magistrate and 2 social workers. The board ensures the child's rights are protected and provides a non-punitive approach to justice. CWC, Child Welfare Committee. They address cases of children in need of care and protecting, focusing on their rehabilitation and integration into society. Principle of juvenile justice. The focus on rehabilitation and social reintegration rather than punishment. Use of observation homes, special homes and counseling services for juveniles. Separate treatment for heinous offences. For heinous offences committed by juveniles aged 16 to 18, the Juvenile Justice Board assess whether the cases should be transferred to a regular court. What is the process of judicial review of administrative and executive actions? Judicial review of administrative and executive actions. Judicial review refers to the powers of courts to review the actions of administrative and executive authorities to ensure they comply with the law, constitution and principles of natural justice. In India, judicial review is a constitutional right and is primarily exercised through Article 32 for enforcement of fundamental rights and Article 226 for writs by High Courts of the Constitution of India. The scope. The courts examine whether administrative and executive actions are unconstitutional, legal, procedurally fair and reasonable. The grounds for judicial review. Illegality. Actions exceeding the powers granted by law, that is ultra vires. Irrationality. Actions that are arbitrary or unreasonable. Procedural impropriety. Failure to follow proper procedures or principles of natural justice, that is right to a fair hearing. Unconstitutionality. Actions conflicting with constitutional provisions or fundamental rights. Types of writs. Courts use several writs to enforce judicial review. They are habeas corpus, to challenge unlawful detention; mandamus, to command to public authority to perform a duty; prohibition to stop a lower court or tribunal from acting beyond its jurisdiction, certiorari to squash an order passed by a subordinate authority, and quo warranto to challenge the legality of a person's authority to hold a public office. Judicial review mechanism. It is typically initiated by a petition or application before the High Court or the Supreme Court. Courts evaluate the legality of the action and may provide remedies like annulment, orders, or compensation. Limitation of judicial review. Courts cannot interfere with decisions based on policy consideration, especially in areas related to national security, foreign relations, or economic policies. Judicial review focuses on the legality and fairness, not the wisdom of the decision. In India, judicial review ensures that the powers of the administrative and executive bodies are exercised within the framework of the law, protecting the rights of citizens. How do domestic violation laws empower women in India? Domestic violence laws in India empower women by providing legal avenues to seek protection, financial support, and justice, while also offering a comprehensive approach to address the various forms of abuse women may experience in their homes. In India, domestic violence laws play a crucial role in empowering women by providing legal protection against abuse and promoting their rights to live with dignity and security. The primary law addressing this issue is the PWDVA, that is Protection of Women from Domestic Violence Act of 2005, which provides a legal framework for addressing various forms of domestic abuse. The PWDVA defines domestic violence in broad terms, including not just physical violence, but also emotional, sexual, verbal, and economic abuse. This comprehensive definition helps in covering various forms of abuse that women may face in domestic settings. Protection orders. The Act empowers women to seek protection orders against the abuser. These orders can prohibit the abuser from committing further acts of violence, approaching the woman, or entering her residence. This provides immediate relief and ensures her safety. Residence and monetary rights. The law grants women the right to reside in the said household whether or not they have ownership rights. Additionally, the Act allows the provision for maintenance and the financial support, empowering women economically and ensuring their financial independence in case of separation or divorce. Access to legal aid and support services. The Act facilitates free legal aid to women, ensuring that they can access legal remedies without financial barriers. Women can seek the help of protection officers and service providers who assist in filing complaints and accessing shelters or medical help. Criminal provisions and penalties. The law allows for criminal action against perpetrators of domestic violence. If the abuser violates protection orders or engages in physical violence, the woman can file a complaint and the abuser may face imprisonment or fines. What is public law? Discuss essential features and sources of it. What is the relevance of it and what are the difficulties? Public law refers to a body of law that governs the relationship between individuals and the state, as well as the relationship between various government bodies. It deals with the issues that affect society as a whole and is concerned with the regulation of public authority. Public law covers constitutional law, administrative law, criminal law, and international law, among other fields. Features. Government authority. Public law governs the actions and powers of the government and public bodies. The primary aim is to serve the public interest, ensuring the welfare and right of the people. Public law regulates the powers of the state and its institutions to avoid misuse of authority and maintain a system of checks and balance. Public law enforces fundamental rights and provides mechanism to challenge the actions of the state that infringe on individual rights. Now it is sources of law. The sources are constitutional law. The Constitution is the supreme source of public law and establishes the structure, powers and duties of government bodies. It also safeguards individual rights and freedoms. Statutory law. Laws enacted by the legislature that define the powers and functions of public authorities as well as regulate interactions between state and citizens. Judicial precedents. The decision of courts, particularly the higher courts, act as a source of public law, providing interpretation and clarification of laws. International treaties and conventions. International agreements and conventions also influence public law, especially in areas like human rights, environmental law, and international relations. Relevance of the study. Understanding different systems. Comparative public law involves the study of public law in different countries, which helps in understanding the diversity of legal systems and institutional structures worldwide. Learning best practices. It allows for identification of best practices and innovative approaches to governance, administration, and the protection of rights that can be adopted by other countries. Promoting global legal cooperation. Comparative public law aids in fostering cooperation and mutual understanding among nations in areas like international law, human rights, and global governance. Constitutional reforms. The study of comparative public law helps in shaping constitutional reforms as it provides insights into successful models of governance and legal frameworks used in other countries. Problems. Cultural and political differences. Legal systems are deeply influenced by the cultural, historical, and political context of each country. This makes direct comparison difficult as legal norms and practices may vary significantly across societies. Complexity of legal system. Different countries may have distinct constitutional structures, judicial approaches, and legal traditions, making it challenging to compare them in a standardized manner. Lack of unified terminology. The terminology used in public law varies from country to country, which may create confusion and hinder effective comparison. Difficulty in practical application. While comparative studies can identify legal trends and ideas, their practical implementation in a different national context may not always be feasible or effective. Discuss federalism in the US. Federalism is a system of government in which two or more levels of government share authority and responsibility. It is in the United States. Federalism in the US is division of power between the national, that is the federal government, and the individual state governments. This system allows both levels of government to share authority over the same geographical territory while maintaining distinct areas of responsibility. US federalism is deeply rooted in the Constitution and has evolved over time. In the context of the US, this means a division of power between the federal government and the state governments. Both levels have their own institutions and operate within their defined spheres of power. Constitutional basis of US federalism. The US Constitution is the supreme law of the land, establishing the framework of federalism. Article 1, Section 8 of the Constitution enumerates the powers of the federal government, such as the ability to regulate commerce, declare war, and coin money. The 10th Amendment reserves powers not delegated to the federal government to the states or the people, reinforcing the principle of federalism and ensuring that states retain sovereignty in areas not expressly covered by federal law. The Supremacy Clause, Article 6, establishes that federal law takes precedence over state law in cases of conflict, emphasizing the primacy of the federal government in certain matters. Shared and reserved power. Enumerated powers. Powers granted specifically to the federal government, such as the power to regulate interstate commerce, maintain a military, and create currency. Reserved powers. Powers that are reserved for the states, such as the regulating education, conducting elections, and overseeing local law enforcement. Concurrent powers. Powers shared by both federal and state governments, such as the power to tax, establish courts, and enforce laws. The role of the US Supreme Court in its federalism. The Supreme Court plays a crucial role in interpreting the Constitution and in resolving conflicts between federal and state powers. In the case of McCullough versus Maryland, it affirmed the supremacy of federal law over state law and upheld the implied powers of the federal government. In Gibbons versus Ogden, it interpreted the federal government's power to regulate interstate commerce broadly, expanding federal authority. Compare judicial activism under US and Indian Constitution. Judicial activism refers to the proactive role of the judiciary in interpreting laws, advancing justice, and addressing issues that might be overlooked by other branches of government. It is characterized by judicial decisions that go beyond the mere interpretation of law to include the creation of new legal principles or striking down of laws. Judicial activism under both US and Indian Constitution has been instrumental in shaping the legal and political landscapes of both nations. They differ in approach, scope, and impact of judicial activism in the two countries. Let's talk about United States. Judicial activism in the US can be tracked back to Marbury versus Madison, where the US Supreme Court established the principle of judicial review, asserting the power of the judiciary to invalidate laws that conflict with the Constitution. This marked the beginning of an active judicial role in shaping constitutional law. Principle of judicial review. The US Constitution under Article 3 grants federal courts the power to interpret the Constitution and decide cases that involve federal laws, treaties, and constitutional issues. Judicial review allows the courts to examine the constitutionality of both federal and state laws. Some landmark cases of judicial activism in the US are Brown versus Board of Education. The Supreme Court declared that racial desegregation in public schools is unconstitutional, overturning the doctrine of separate but equal established by Plessy versus Ferguson. Roe versus Wade, the court legalized abortion by interpreting the right to privacy under the Due Process Clause of the 14th Amendment. Obergefell versus Hodges case, the Supreme Court ruled that the right to marry is a fundamental right guaranteed by the Constitution, legalizing same-sex marriage nationwide. The limitations. Judicial activism in the US is constrained by the principle of judicial restraint, where courts refrain from overstepping their role and respect the decision of elected branches of government, particularly in matters of public policy. Judicial activism in India. Historical context. Judicial activism in India. Judicial activism in India has its root in the post-independence era, especially after the 1970s, when the Indian judiciary began adopting a more proactive approach in interpreting the Constitution, particularly in cases involving fundamental rights. Constitutional framework. The Indian Constitution under Article 13 provides for judicial review, allowing courts to strike down laws that violate the Constitution. However, unlike the US Constitution, the Indian judiciary often engages in activism by interpreting fundamental rights broadly, even in the absence of direct legislative action. Landmark cases of judicial activism in India. Keswanand Bharati versus State of Kerala. The Supreme Court established the basic structure doctrine, which limits the power of Parliament to amend the Constitution, asserting judicial authority in constitutional matters. In Maneka Gandhi versus Union of India, the court expanded the scope of Article 21, that is the right to life and personal liberty, to include the right to live with dignity and freedom from arbitrary laws, thus increasing judicial intervention. In Vishaka versus State of Rajasthan, the Supreme Court issued guidelines to prevent sexual harassment in the workplace, illustrating how the judiciary had stepped in to protect rights even in the absence of adequate legislative frameworks. Right to privacy. The court declared the right to privacy a fundamental right under Article 21, influencing debates on data protection and surveillance. Public interest litigation role. One of the hallmarks of judicial activism in India is the use of PIL, allowing any public-spirited individual or organization to approach the courts to seek justice on behalf of marginalized groups. PIL has been used extensively in cases involving environmental protection, human rights, and social justice. While the Indian judiciary has a broad mandate to protect rights, it has its limitations. Its activism is sometimes constrained by doctrine of separation powers, especially in matters of public policy where courts avoid interfering with the role of the elected government. Comparison of judicial activism in the US and India. Both the US and Indian Constitution provide for judicial review, but the scope of judicial activism differs. The US courts generally engage in judicial activism by interpreting the Constitution and expanding rights, while the Indian courts have often gone beyond interpretation to create new legal frameworks, especially through PIL and social justice intervention. Nature of activism. In the US, judicial activism tends to focus on the protection of individual rights, that is abortion right, same-sex marriage rights, and issues of federalism. In contrast, judicial activism in India is broader, addressing social justice issues, public health and environmental protection, often stepping in when legislative or executive actions are perceived as inadequate. Judicial restraint. Both countries have debates over judicial activism versus judicial restraint. In the US, there is a strong tradition of judicial restraint in certain matters, especially in the context of federalism and state rights. In India, judicial activism often occurs when the courts perceive a gap in legislation action or when citizens' fundamental rights are violated. PIL. One unique feature of Indian judicial activism is the use of PIL, which allows courts to hear cases in the public interest without requiring direct involvement from the affected parties. In the US, there is no equivalent mechanism for citizen-driven litigation on behalf of marginalized groups. Compare the President of US and India. Compare the President of US and The roles of the Presidents of the United States and India are central to their respective governments, but they differ significantly in their powers, functions, and the political context in which they operate. Constitutional framework. The President of the United States is both the head of the state and head of the government, which means the President holds both ceremonial and executive powers. The roles of the US President is defined in the US Constitution primarily in Article 2, which vests executive authority in the President. The US follows a presidential system of government, meaning that the President is directly elected by the people and serves as the chief executive, separate from the legislature. In India, the President is the head of the state but not the head of the government. The Prime Minister is the head of the government and exercises executive powers. The role of the Indian President is defined in the Constitution of India in Article 52. The President is a ceremonial figurehead with most executive powers vested in the Council of Ministers headed by the Prime Minister. India follows a parliamentary system of government where the President's powers are largely symbolic and the real executive authority lies with the Prime Minister and the Cabinet. Powers and functions. Executive powers. The US President has significant executive authority, including the power to issue executive orders, direct the federal administration, and appoint key officials such as cabinet members, federal judges, and ambassadors, subject to Senate confirmation. Legislative power. The President has the power to veto bills passed by the Congress, although this veto can be overridden by a two-thirds majority in both houses of Congress. The President can also propose legislation and deliver the State of the Union address to Congress. Military powers. The President is the Commander-in-Chief of the United States Armed Forces with authority to direct military actions through major military decisions often require congressional approval or authorization. Foreign policy. The President has the power to negotiate treaties with Senate ratification and conduct foreign relations. Appointment power. The President appoints federal judges, including Supreme Court justices, subject to Senate approval. India. The Indian President's executive powers are exercised on the advice of the Prime Minister and the Council of Ministers. The legislative power. The President's legislative power are largely formal. The President summons, prorogues, and dissolves the Parliament and gives assent to bills passed by the Parliament for them to become law. The President can also withhold assent to a bill or return a bill except in the case of money bills. Military power. The Indian President is the Supreme Commander of the Armed Forces, but military decisions are made by the government, particularly the Prime Minister and the Defense Minister. Foreign policy. The President represents India in foreign affairs and signs treaties and agreements, but the real foreign policy decisions are made by the government. Appointment power. The President appoints the Prime Minister and other key government officials, including judges and governors, but these appointments are made based on the advice of the Prime Minister. Impeachment and removal. The President of the United States can be impeached by the House of Representatives for committing high crimes and misdemeanors and removed from office if convicted by the Senate. The process of impeachment is a political process and the President can be impeached and removed from office only through significant majority votes. Till date, President Andrew Johnson, President Bill Clinton, and President Donald Trump have been impeached, but none have been convicted. In India, the President can be impeached for violation of the Constitution. The process involves a proposal from either House of Parliament which must be approved by a two-thirds majority in both houses before being passed to the other house. Removal of the president is a complex process, but it remains largely theoretical as no Indian president has ever been impeached. Compare Ombudsman in Sweden and Lokpal in India. The Ombudsman in Sweden and the Lokpal in India are both institutions designed to address complaints of public grievances, especially in cases involving maladministration or corruption. The two institutions differ in their historical evolution, power, structure, and specific functions within their respective system of governance. Historical background. In Sweden, the Ombudsman was established in 1809 through the instrument of government. It was initially created to ensure that government officials did not violate the rights of citizens and the public administration was accountable to the people. The institution is deeply rooted in the Scandinavian tradition of ensuring state accountability, transparency, and fairness in the public sector. In India, the Lokpal was established much later in 2013 after a long history of debate and efforts to combat corruption in the public offices. The movement for establishing the Lokpal gained significant movement in 2011 when Anna Hazare, a social activist, led a nationwide campaign demanding the creation of the Lokpal as an independent body to address corruption at the highest levels of government. Mandate function. Sweden Ombudsman had a broad mandate to ensure that public authorities, including government, follow the law and respect citizens' rights. The Ombudsman can investigate cases of maladministration, human rights violations, and unfair treatment by public servants or state agencies. The Ombudsman can issue recommendations but does not have the power to impose binding penalties or prosecute individuals. However, the office can refer cases to courts or the public prosecutor when necessary. In India, the Lokpal was established specifically to address corruption in public offices, including those of the Prime Minister, ministers, members of Parliament, and government officials of Group A and B. The Lokpal has the power to investigate allegations of corruption, misconduct, and abuse of office by public servants. The institution has a more punitive role than the Swedish Ombudsman, with the authority to inquire, investigate, and recommend criminal action, including filing cases with the Central Bureau of Investigation. Powers and jurisdiction. The Swedish Ombudsman has significant investigatory powers, allowing them to review all actions of public authorities, including government departments and local administrations. The Ombudsman's decisions are non-binding but can be powerful in public opinion, and they can refer matters to the Parliament or courts for further action. In India, the Lokpal is equipped with more direct powers to deal with corruption cases and has the authority to investigate complaints against the highest officers of government. The Lokpal has the authority to initiate investigation or refer cases to the CBI and other authorities for further prosecution. The Lokpal can take action against public servants found guilty of corruption, abuse of office, or misconduct and recommend penalties, including dismissal or criminal proceedings. Unlike the Swedish Ombudsman, the Lokpal's recommendations have a legal backing and can lead to tangible legal consequences. Compare the Ombudsman system in UK and US. The comparison of the Ombudsman system in the United Kingdom and United States both have adopted the Ombudsman model to address grievances against government bodies, but there are significant differences in how each system operates, their structure, powers and functions. Historical background. The Ombudsman system in the UK was established in 1967 with the creation of the Parliamentary Commissioner for Administration, that is PCA. The system was introduced to hold government departments accountable and to provide a mechanism for citizens to complain about maladministration in public services. The Ombudsman system in the US is decentralized and it does not have a single nationwide institution. Instead, the US has several Ombudsman offices both at the federal and state levels. The Ombudsman model in the US has evolved over time, with each state also having the option to create its own Ombudsman office, such as the California Ombudsman and the Texas Ombudsman, with a strong focus on consumer rights, veteran services and public health issues. Mandated functions. The UK Ombudsman has a clear mandate to investigate complaints of maladministration by public bodies, focusing primarily on the public sector, including government departments, the National Health Services, and local authorities. The Ombudsman can investigate complaints relating to unfair treatment, negligence, delay, bias, or poor service delivery by public services. United States Ombudsman system varies widely in its scope. Each Ombudsman office has a specific mandate depending on its function, and not all ombudsmen are focused on maladministration in the public sector. State-level ombudsmen often deal with consumer protection, veterans affairs, child welfare, and issues related to public health or corrections. At the federal level, the US government may have specialized ombudsmen for specific areas such as military grievances or whistleblower protection. Powers and function. The United Kingdom Ombudsman has the power to investigate complaints, issue recommendations, and provide remedies for individuals affected by poor government decisions or services. However, the Ombudsman does not have binding legal power. The US Ombudsman system powers depends on the office in question. Federal Ombudsmen, such as the US Ombudsman for Veteran Affairs, have the authority to intervene in specific grievances and work towards resolutions by facilitating communication between the complainants and relevant agencies. They can recommend corrective actions but do not have the power to issue binding decisions. Discuss the Indian law governing juvenile justice. The juvenile justice system in India is primarily governed by laws that aim to protect the rehabilitate children who are in conflict with the law. These laws seeks to balance the rights of juveniles with the need to ensure justice, emphasizing rehabilitation and reformation rather than punishment. Over the time, India has made significant efforts in reforming the juvenile justice system, particularly through the Juvenile Justice Care and Protection of Children Act 2015, which replaced the previous Juvenile Justice Care and Protection of Children Act 2000. Juvenile justice. It is the principal legislation governing juveniles in India, and it applies to both children in conflict with law and children in need of care and protection. We are talking about the Juvenile Justice Care and Protection Act of 2015. The act prioritizes the rehabilitation and reformation of juveniles rather than their punishment. It aims to restore the child to a normal life, keeping their best interest in mind. The best interest of the child are to be paramount consideration in all decisions made under the law. The process. Inquiry process. When a juvenile is accused of committing a crime, the case is referred to the Juvenile Justice Board. The board conducts an inquiry during which it determines the juvenile's age, mental and physical condition, and the nature of the offence. The inquiry is conducted in an informal manner, aiming to provide a child-friendly environment. Rehabilitation and reintegration. If the juvenile is found guilty, the board determines appropriate rehabilitation measures such as sending the child to a juvenile home, engaging in educational programs or counseling. The board emphasizes reformation, and after serving the sentence, the juvenile is reintegrated into society through proper care and supervision. The role of the state and NGOs. The state is responsible for ensuring that juveniles have access to basic rights such as education, health care, and safety. The Act also encourages the participation of NGOs in the rehabilitation process by setting up rehabilitation centers and homes. Special provisions for juvenile offenders. Special homes and juvenile homes. The Act mandates the establishment of special homes for juveniles, which are designed to provide a rehabilitative environment. These homes are different from adult prisons and focus on education, vocational training, and therapy. Rehabilitation of juveniles in need. For children who are not in conflict with the law but are in need of care and protection, the Act ensures that they are placed in care homes or with foster families. The law emphasizes social reintegration and strives to provide a better future for such children. Role of the judiciary. The Indian judiciary plays a key role in ensuring the implementation of the Juvenile Justice Act. Various judgments such as Pratap Singh versus State of Jharkhand have stressed that the best interest of the juvenile should be the foremost concern. The judiciary also acts as a check on the excesses of the system by reviewing cases where juveniles are denied access to rehabilitation or when their human rights are violated. This is the end of this episode. I hope you found the contents useful. So please do hit the subscribe button and click on the bell icon to be the first to get next SSQN. Comment, it guides me to set the right questions for you. Like, as it encourages me, and share it. Thank you for watching me. Thank you so much.